Section 17 of the Haraabah Ordinance lays out the severe punishments for those convicted of Haraabah. If the act of Haraabah results in the murder of a victim, the perpetrator faces the death penalty or life imprisonment. This highlights the gravity with which the law views taking a life during such a crime. In addition to imprisonment or death, the court may also impose a fine on the convicted individual. However, Section 18 provides exceptions to these harsh punishments. If the act of Haraabah does not result in death or grievous hurt, the punishments outlined in Section 17 do not apply. This means that lesser forms of harm, while still considered criminal offences, carry different penalties. The law recognizes a distinction in severity based on the outcome of the Haraabah Act. This differentiation in punishment aims to ensure that the penalty aligns with the severity of the crime committed. Section 19 of the Ordinance addresses the issue of property stolen during Haraabah. It mandates that any property seized during an act of Haraabah must be returned to its rightful owner. This provision ensures that victims are not further disadvantaged by the loss of their possessions. The court is responsible for facilitating the return of stolen goods, emphasizing the importance of restitution in the eyes of the law. Section 20 deals with instances of Haraabah where the punishment falls under the category of Tazir. Tazir refers to punishments that are left to the discretion of the judge within Islamic legal limits. This section allows for flexibility in sentencing for Haraabah cases that do not fit the specific criteria outlined in Section 17. The judge can consider mitigating or aggravating circumstances when determining a just punishment under Tazir. Section 4, addressing highway robbery. Sections 21 and 22. Section 21 of the Haraabah Ordinance focuses on two specific forms of highway robbery, rassagiri and patharidari. Rassagiri involves the act of waylaying and robbing individuals, typically in groups. Patharidari, on the other hand, refers to the robbing of individuals, often travelers, by scattering their belongings and then quickly seizing valuables. Both practices are considered serious crimes under the Ordinance due to their inherent threat to public safety and order. Attempting to commit any of the offences outlined in the Haraabah Ordinance, including Haraabah itself, rassagiri and patharidari, is also deemed a criminal act under Section 22. Even if the attempt is unsuccessful, the law recognizes the intent and potential for harm. The punishment for an attempted offence is typically less severe than that for a completed offence, but it still carries legal consequences. This provision underscores the proactive stance of the law in deterring criminal behaviour. Section 5. Legal frameworks and procedures. Sections 23 and 24. Section 23 of the Haraabah Ordinance clarifies the relationship between this specific ordinance and the broader Pakistan Penal Code of 1860. It states that any provisions within the Pakistan Penal Code that contradict or are inconsistent with the Haraabah Ordinance are superseded by the latter. This ensures that the Haraabah Ordinance takes precedence in cases specifically dealing with Haraabah and related offences. Section 24 further clarifies the procedural aspects of handling Haraabah cases by linking the Ordinance to the Code of Criminal Procedure, 1898. It states that the Code of Criminal Procedure, which outlines the procedures for investigations, arrests, trials, and other criminal justice processes, applies to cases under the Haraabah Ordinance. This provision ensures a standardized and legally sound approach to investigating and prosecuting Haraabah offences. Section 6. Judicial Requirements and Safeguards, Sections 25 and 26. Section 25 of the Haraabah Ordinance mandates that the presiding officer in a trial involving Haraabah offences must be a Muslim. This requirement stems from the Islamic legal principles that form the basis of the Ordinance. The presence of a Muslim presiding officer is deemed essential to ensure that the proceedings and judgments adhere to the spirit and interpretations of Islamic law. Section 26, the final section of the Haraabah Ordinance, introduces saving provisions. These provisions act as safeguards to prevent the ordinance from being applied retroactively. This means that any act committed before the enactment of the Haraabah Ordinance cannot be tried or punished under this specific law.